The pre-trial visit, we find, alleviates quite a lot of nerves. It removes the expectations of fear that people would usually have. They get a chance to physically see the court, and that's a big step for most people. When you're doing your pre-trial visit, you will be escorted by a volunteer or a member of staff. People can come in off the street to watch trials, but generally that doesn't happen. You tend to find the main people sitting in the public gallery would be relatives of a defendant, relatives of an injured party or a witness, and usually the police. They would be the only people there. Now, you need to be aware that if your accused person is not on remand, i.e. in prison or in the dock, he could be sitting in the public gallery. This is where all the legal representatives sit. And basically what happens is, although this is the most informal level of court service, the prosecutors tend to sit in this middle row here. And the defence representative, or the solicitor representing the accused person, he would sit in the row in front of them. So when you get to the witness box, you're going to be sworn in as a witness. If you're going to swear on the Bible, they'll ask you to take the Bible in your right hand. And normally the court clerk will lead you through the oath as you hold the Bible. And it's the one you see in television dramas and documentaries. I swear by Almighty God that my evidence to the court shall be the truth, the whole truth, and nothing but the truth. If you have an issue or you're non-Christian, you have no Christian beliefs, what you'd tell the clerk, I would like to affirm. This takes the Bible out of the context, and the clerk will then give you the affirmation. And again, you'll usually have a laminated copy, or the clerk will lead you through it. The affirmation goes along the lines, I do solemnly, sincerely declare and affirm that my evidence to the court is the truth, the whole truth, and nothing but the truth. So from this point, the prosecutor is going to ask you, or tell you, in other words, please speak clearly into the microphone and please direct your answers to his or her worship. And then what they will do is start to ask you questions that are based on your statement. They need to be aware at this point that the judge doesn't understand, has never heard any of this case before, so the more clearly the victim or witness can tell their story, the better. And the prosecutor will design questions that way, so that will get an answer that tells the whole story. So this is where the judge normally sits. This is what they call the bench. A lot of questions victims and witnesses would have is, what's the judge going to be like? Are they going to ask me questions? What do they wear? And it's quite straightforward. At this level of court, the judge is dressed in normal street clothes, business suit. Judges normally take quite a bit of notes, and they very rarely ask you questions. If they tend to get a bit confused about a point you're trying to make, they will generally ask you a question that's closed, which means it's a yes or a no answer. And if you have to speak to the judge, normally you would address him or her, as your worship. Once the prosecutor stops asking questions, they will give the witness or the victim another instruction to remain seated where they are, that his friend or her friend or colleague has questions they want to ask them. This generally means that the witness is being passed over for cross-examination, and cross-examination is the bit that nobody likes. The role of the defence practitioner is to challenge the evidence of the victim or the witness, and they can be quite robust about that. It's not personal, although when you're seated in the witness box and under pressure, it can seem intensely personal. At that point, the judge will offer the prosecutor an opportunity to re-examine the witness. Basically, that means that if the prosecutor wants to tidy up a few loose ends, it may seem the witness has got confused or contradicted themselves, the prosecutor then has an opportunity to tidy that up by asking a few straightforward questions. This is where the press sit. Now, the press can attend the court because it's openness and transparency. They're entitled to report in certain cases, unless it has been embargoed, which means the judge doesn't allow them to name people. And quite commonly, people are afraid of their name appearing in the press. At magistrates level, that very rarely happens. The press are in attendance, but generally they will speak to someone before they print anything. So therefore they'll give the person an opportunity to say, I don't want my name in the press, and it will be reported that way. The dock is very rarely used at magistrates' court. We spoke earlier on about sometimes you could encounter a defendant sitting in the public gallery. Well, if a defendant is on remand or has been held in remand by the police for any length of time, the police could maybe hold someone until they sober up before questioning. That's called remand. And if that were to happen, although that person then gets police bail, when they appear at court, rather than sit in the public gallery, the accused person then has to go in to the dock, where they're accompanied usually by 1 or 2 prison officers. So normally the witness service would escort the witness out of the court to wherever they wanted to go. They've got the opportunity, if they want and they feel comfortable, to sit in the public gallery. They can go back to the witness waiting room, get themselves tea or coffee and wait on the outcome of the contest, or they can in fact go home because they have ostensibly been released as a witness from the court by the judge.